Eric Briggs under brutal cross-examination here. We're going to talk about it right now with my guest, who I've never met before, but I'm going to have him on, and he's a great criminal defense attorney from everything I've read. Eric Johnson, you're from Atlanta, but the reason why you're really here is not because of your wife, okay, but because you are normally from Chicago, or you hail from Chicago and still have family there. That's correct, right?
That's correct. I was born and raised in Chicago. All my family still lives there.
So tell me, from somebody from Chicago who's also a criminal defense attorney, what do you think of this cross-examination? Common sense or nonsense?
Well, I think a lot of it is, I say a little bit of both. Some of it is common sense, some of it is nonsense. I mean, the cross-examiner is trying to get to the point to point out all of the details and the facts that the officers fabricated in trying to create this cover-up. The fact of the matter is they have to come up with something to justify their being unsafe, feeling unsafe, to try to cover this up and try to say that it was a justifiable shooting.
And the investigator says at one point that the officer, Detective March, told him it was a 4-inch knife, and that before he was shot, before Laquan McDonald was shot, that the police officers identified themselves as Chicago police officers, both of which are probably sort of untrue. The identification, because you could see them, and number one, it was a 3-inch knife. What bearing does that have on the credibility of Mr. Briggs from the medical examiner's office?
Well, what it does is it shows that there are inconsistencies and that the officers are trying to, that they had knowledge that they had done something that was wrong. The fact that they're trying to make the situation more dangerous than it was plays into the old narrative that these officers used, that they feared for their safety. So the trying to make the knife bigger or anything else is into that.
Wow. You're telling me that attorneys play games. Well, we have to go to a quick break, Eric. We're back on the other side. We're going to listen to more. No more breaks. I'm sorry. We don't have more break. We have more testimony, and we're going to listen to more testimony. Let's hear what happens.
Great.
Well, see, that's some of the questions you can ask in front of a judge. You can't ask for a jury. Mr. Briggs, how many times have you met with the special prosecutors? Which ones? Oh, Eric Johnson, criminal defense attorney from Atlanta, but who has Chicago roots. Tell us about someone from Chicago, the reputation of the Chicago Police Department, and whether this judge would know of the reputation of the Chicago Police Department.
Well, this judge has come up through the Cook County justice system, so they would have some knowledge of the history of the Chicago Police Department. And having lived there and going back very frequently, I can say that they do not have a very good reputation as it goes to the populace. I mean, there's been numerous cases over years of corruption in the Chicago Police Department within my lifetime and even before my lifetime, even so far going back.
Yeah, I'm sorry. Do you think this type of cross-examination does anything to undercut what the judge may know about this case? That in fact, former Detective March was called basically the critical touchstone of the cover-up. Do you think this cross-examination does that, or does it fail?
Well, I think it does that because what they're really trying to get at is the inconsistencies and any way in which proper procedures was not followed to possibly show some form of cover-up.
Okay, so we're going to continue to cover this case. First, we have to go to break, but I can't wait to see who and what's on the other side because wow is all I can say as a criminal defense attorney. Let's go to break. Eric Johnson, my great guest, who just watched that clip of Sergeant Larry Snelling with me from the Chicago Police Department on the Chicago cop cover-up trial. Now, it seems to me, Eric, they're discussing use of force, all right? And you know that you can only meet deadly force with deadly force. You can't, if somebody is throwing a tic-tac in the street, you can't shoot somebody for it. But it seems to me that the standard over the years has changed, that it used to be that you only would shoot somebody with a gun, and that's why cops had throwaway guns. Now it seems to me it's kind of going downhill. Tell me about this slope that we're on.
Well, we're definitely on a slippery slope where the officer's fear for his safety is basically overwhelming his necessity for his training. I mean, the officers in this case are shooting first, asking questions later, and not doing anything else to diffuse the situation. And the unfortunate aspect of it is that it seems that this mentality has been directed mostly toward African-American men. Because if you look at most of the situations involving mass shooters who are not African-American, a lot of them are taken into custody without any type of death or any shooting being taken place. So we definitely have to look at the slippery slope where it seems that anytime you see an African-American man with a weapon of any type, that he's considered a deadly threat, and then lethal force is authorized.
And that's a significant social area and social discussion we must have. The shooting of the black church members by the white supremacist young man comes to mind. He was taken in. And so we're going to hear more about whether this use of deadly force could anyway be justified in the Laquan McDonald case by listening to Sergeant Snelling more. So this is Sergeant Larry Snelling from the Chicago Police Department in the Chicago cop cover-up case, discussing what an officer can do to avoid shooting somebody. Time, distance. He talks the difference between somebody who is an armed active resistor and somebody who's an actual assailant. So I'd like to bring our guest back in, Eric Johnson, who is a criminal defense attorney in Atlanta, formerly from Chicago and still has family there, so obviously is very interested in this case and the social importance of this case. Eric, there was a report by the Attorney General back in 2017, I believe, that said Chicago had, as a pattern of practice, used excessive force. Here the attorneys have a kid who at some point did use a knife against a police car. Does that use of the knife make him an armed assailant or an active resistor?
Well, I would just say that it makes him an armed suspect. I wouldn't say that he's an active resistor or anything else like that. The bottom line is he was armed. He committed an act of vandalism or basically property damage against the vehicle, none of which justifies shooting him. At the time of his shooting on the video, he was armed with the knife, but he was more than arm's distance from the officer. So the fact that they can say that there was a threat, or I don't believe that there's any way he could be considered an assailant at that particular time, especially using the officer's words of the weapon system and the delivery system. The weapon system being the knife, but how was he going to deliver an injury that far away?
All right. So we also know that indeed one jury has found Jason Van Dyke, who shot Laquan McDonald, guilty of second-degree murder. Now we're discussing whether or not there was a cover-up of this. And when we come back, we'll talk more about whether or not this case has become about the justification for the shooting, or was there a cover-up? It's an interesting case. But first, we have to obviously do other things, which is take a break. Please stay with us and come on back. Oh, Anthony Velez, we're back to O.J. Simpson. Let me ask my guest, Eric Johnson, is it ever going to go away?
I sincerely hope so. I'm tired of it, just like everybody else.
I'm not going to name names, but they better have some really good goods if they're going to name names on TV of somebody else who is a murderer. That's all I can say. If not, we also do defense of defamation cases, or not. It depends, I guess. But anyhow, right?
Unless it's someone famous, who really cares? They can't try OJ again, so, who cares?
Yeah, well, but, he still garners public attention. But anyhow, the more important case that we've been covering, and that is the Chicago cop cover-up case. But we just didn't get here today in a vacuum. And by the way, you're not missing anything. They're not back yet. We're following that courtroom so that you don't miss anything. But how did we get here? It really started with this cover-up, with the shooting of 17-year-old Laquan McDonald. And we also know that there has been a trial before there with Jason Van Dyke, a police officer who was convicted of second-degree murder. But there's a lot to it. And we have a little bit of a news package on it. Actually, it's a big news package on it because you know what? It's moderated by our own Rachel Stockman. It's fabulous. I can't wait to listen to it, and you probably need to listen to it too because it's just something you haven't heard before. So that was clips from how we got here, and you heard Jason Van Dyke on the stand discussing the crux of what forms really the basis of this cover-up today. Jason Van Dyke told this jury that Laquan McDonald, 17, was advancing on him with a knife, but we don't see it on that video. And obviously, if we didn't see it, neither did those three officers who are seated here today. Eric Johnson from Atlanta, let me ask you this. I have the reports here, okay? Here's the reports that were submitted, right? They show that allegedly Laquan McDonald was an assailant. What say you? Was he an assailant?
I say nay. I say nay. He was walking in the general direction, but not directly toward the officer. when he was shot. The video is very clear on that.
Let me ask you this. The cops, the attorneys today are defending their clients, and they're discussing, this case is now again about whether or not there was a right to shoot Laquan McDonald. Haven't we already litigated that in the Jason Van Dyke case? Why are we discussing it again now?
Well, they're trying to say that there was a justification for shooting him to try to justify their actions for the cover-up. I mean, you can't have one without the other. So it would seem to me that the video evidence would show that there is some form of cover-up in this situation.
So let's see of what Eric just said. We're going to listen to Jason Van Dyke testify in his previous trial. Let's see if maybe the present lawyers are doing it better or whether this is all fabrication. Well, this is Officer Jason Van Dyke, who testified in his own trial in which he was convicted. And while we're waiting for the Chicago cop cover-up case to restart from their lunch, they're not in the courtroom yet, so you're not missing anything. I'd like to bring my guest, Eric Johnson, back in just for some discussion. Now, Eric, I always say that when a defendant testifies, unless you really need them or they're really good, it's called #PrisonExpress. Did he help himself in any way, or was he going to get convicted no matter what happened?
Well, I think the video was very, very damning in this situation, especially with his claims that the youth was advancing on him. I mean, if he was going to come up with something, he should have done something better than that, because the video evidence totally blew his story out of the water. So
yeah, and also when you testify as a defendant, if your expert was just on the stand like 2 days before you or a day before you and presents a video animation of what you saw because you're the client, and then you get on the stand and say, well, that's not what I saw, that doesn't help, does it?
Well, no, it doesn't help. But unfortunately, defense attorneys have to deal with the fact that the right to testify is up to the client. So given the charges, and if he wanted to testify, the defense attorney would have to let him, even if it's something that they didn't think they wanted to do.
And one of the other things that defense attorneys, that clients have, they have the right to say whether they're going to testify. They also have the right to say whether there was going to be a jury or a non-jury trial. And we know with the 3 detectives who were waiting to come back to trial after lunch in the Chicago cop cover-up case on the stand, that they elected to have a judge, not a jury, hear their case. Is there an advantage for them? Do they think, does he think, each one of them, he being 3 he's, that they're going to have a better or more favorable verdict from a judge?
Well, I think so. And the reason being, in this case, really what they're looking at, because of the charges that they have, you're looking at whether or not these officers followed proper procedure or have deviated from protocol, which is something more of a legal standard or a procedural standard. So they probably believe that a judge would be more willing to look at things in that light. Wow. If they had a jury trial, the overwhelming fact that the people think that the Chicago police is systematically corrupt, anything having to do with procedure will probably fall back against them. So a bench trial in this case was probably the best choice.
Well, you know, whenever you start talking about procedures and bench trials and strategy, we always have to remember that a 17-year-old young man lost his life. We have to remember that officers' careers and their families have been hurt, that people have been hurt, and that a lot of lives have been ruined. So we talk about strategy and all, but in the real world, it's about real consequences for a lot of people. With that thought, let's go to break. Hi, we're back. We're monitoring the trial in the courtroom. We have you covered. They haven't started yet. The Chicago cop cover-up case for the cover-up of the shooting of Laquan McDonald, but we do have some, maybe a look-see of what may or who may be coming up. It's been reported that in the hallway of the courthouse, and that's the courthouse where this little tiny courtroom is, as you can see, that Mr. Jose Torres and his son are waiting. Now, why would they be waiting? Well, they testified in the shooting trial, the murder trial of Jason Van Dyke. And they testified because they actually witnessed and heard, ear witnesses, eyewitnesses in part, the shooting, the death of 17-year-old Laquan McDonald. This is a picture that you're looking at right now in the first trial, so we anticipate that the prosecutors are going to call them both, or one of them, at least discuss what they talked about in the Jason Van Dyke trial, which that Laquan was not an assailant. Laquan was not an advancing assailant. Laquan was not a threat, and that there were 16 shots fired. I'd like to bring my guest back in to discuss this briefly, if we can. Hopefully it'll be brief, and not because of you, Eric, but because we're just sitting on edge waiting for this case to resume after hearing 3 witnesses in the last 2 days. Now, what difference does it make whether or not there were witnesses to the shooting that were not the cops? I mean, I know the answer. You know the answer. Tell our viewers.
Independent witnesses who are not interested or biased in the result. These are individuals who basically have nothing to hide and no reason to lie for the police. So therefore, they would be witnesses who would tell exactly what they saw.
Okay, but it seems to me that we've now come back a circle, that we're discussing again whether there was justification for the shooting of Laquan McDonald, who was 17 at the time, not whether or not there was a cover-up for the shooting. Do we need to relitigate that issue, Eric? Do we need to have this judge find that the shooting was not justified to find there is a cover-up, or can the cover-up stand alone?
Well, I think the cover-up can stand alone as far as them being found guilty of it. However, the facts and circumstances of the shooting would provide the basis for the cover-up. So it's hard to establish the cover-up without establishing, once again, for this particular jury, the problems with the shooting in and of itself.
Yes, for this judge. That's a great point. We're going to take a listen until they come back this afternoon of that first trial of Mr. Perez's testimony. So we're still listening to Joseph McElligott. He was defendant Gaffney's partner the night that Laquan McDonald was shot by Jason Van Dyke. I do want to point out that there is, and Eric also is with me, that there's a screen there. We can't see what's being played. There's something happened. The judge has ordered, when we came back after lunch, the removal, and I'm going to read this, of the monitor due to the fact that some of the exhibits have shown, and others that will be shown, have the personal information of the officers or witnesses on them. The exhibits will not be made public even after the trial. For this reason, she has removed the monitor going forward. Also, any documents that have been used on air or in social media need to be removed immediately per the judge's order. So that's the judge's order. If we want to continue to show this trial, we can't violate an order. Eric Johnson, you've been with me. If you had to say who did better today from what you watched, I know trials aren't boxing matches, but who? Prosecution or defense?
Well, I think the prosecution did very well with what they had to do, but I think overall I think that they're going to win the case.
Well, thank you very much. I told Eric he had to keep it short. We're up against a hard break pretty soon. I hope to have you back. Thank you so much for your insights today. Hopefully next time we'll have more time to talk. This is the case of the Chicago cop cover-up from the shooting of Laquan McDonald, who died, as you know. We're going to continue to cover this case all week until it's finished. Aaron will be next. You know him well, the Daily Debrief. I want you to stay with us. I will be back tomorrow from 3 to 5. Stay tuned.